my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. Part of the world of family law involves custody issues. It involves the determination by the court that as a result of a hearing or otherwise, so-and-so will get custody, so-and-so will not. So-and-so will have parenting time, the child will live here most of the time, the child will visit there sometime. I mean, that's custody orders. That's how they go. Sometimes, though, after a custody order is determined, and the court ruled, for example, that mom will have custody of the child, sometimes 6 months, a year, 2 years will go by, and all of a sudden, the other side will file a motion to change it. Will file a motion to modify the custody order. They're not happy with it anymore. They don't feel that they get enough time. They're paying too much child support, so they want it lowered, you know, that kind of thing. How do you defend against that? What do you do? Well, number one, you call your lawyer immediately. If the lawyer who handled the case before is no longer available to you, call somebody else. But understand very clearly one thing. Matters involving custody are complicated. There's a dozen factors that the court uses to evaluate custody determinations. You're not going to know how to deal with that on your own, any more so than you'd be able to pull your own teeth or do your own surgery. You can't do it, so don't even try. Get a lawyer involved immediately. This involves your child. That's number one. Number two, the lawyer is going to have to see the documents. So you're going to have to bring the lawyer, copy of the motion, and what the lawyer is going to have to do, and be prepared to do this, going to have to go over what's been going on since this custody order was in effect. This is an order from 2020. It's now 2024. How have things been going? What have the problems been? You have to be candid with your lawyer and tell them, look, this has worked out. This, not so great. I'm supposed to have the child available for him to pick up, but honestly, I don't, because I don't get home. My shift has been changed, and I don't get home that early. So it's been a half hour by the time he gets to pick up the child, half hour later than he's supposed to. So the question, well, did you give him an extra half hour? Well, no. You see, these kind of things, you got to be honest with your lawyer. Much like a patient has to be honest with his doctor over the symptoms so the doctor can give the right remedy. Same with your lawyer. So you're going to have to be candid with your lawyer about how it's been working so far. And then your lawyer will be able to, A, draft an answer to this motion, and B, defend you at the contested hearing. Now, with these motions to change custody, the court's got to be satisfied of, number one, that there's been a significant change in the circumstances that justifies even looking at the custody again. So that's a threshold question. So you guys can bicker back and forth about this, and this lawyer can bring that, and this lawyer can bring back. At the end of the day, the court might figure, you know what? This is a different situation. It is modified somewhat. The schedule has changed a little bit because of work and other things. However, I don't deem it a significant circumstance to justify redoing the order. I will, however, order that on the days that you don't get your child until 30 minutes after you're supposed to, you get to keep your child an extra 30 minutes. In other words, the court has the discretion to do that. The court might find that there is no change, or that the change in circumstances just isn't great enough to revisit the custody order. Because remember, a new custody analysis is a very big deal, involving a lot of time, costing the parties a lot of money, and the court may not feel that it's justified by what's before it, but the court may find that some minor accommodation is appropriate, and it may actually modify the order in that way. Now, every case is case specific. If you have questions about yours, reach out, and we'll be glad to help you out.